Hi, welcome to Commercial Law Tutorials. Under the topic Law of Contract, we have already covered the definition and formation of a contract, then offer and acceptance, advertisements, valid, void and voidable contracts, and also the important terms used in the law of contract. Today we are moving on to lesson number 6, that is breach of contract and the remedies to breach of contract. During this lesson, first of all, we are going to define what is breach of contract, then the different types or forms of breach. Next, the remedies to breach of contract. We will also look at the express terms which entitles cancellation of a contract. Then at the end of the lesson, we will look at popular exam questions relating to this lesson. First of all, let us define what breach of contract is. Breach of contract is an act of breaking the terms set out in a contract, that is, failing to deliver according to the terms of the agreement set out in the contract. A party to a contract fails to observe one or more terms set out in the contract without lawful excuse. That is, he fails to honor his obligations under the contract. That is breach of contract. So in breach of contract, we have got material terms and non-material terms that are considered when we are talking about breach of contract. In the case of material terms, the injured party has an election to either uphold or cancel the contract, while if the breach is of a non-material term, the injured party cannot cancel the contract but may claim damages suffered as a result of the breach. Let us look at the forms of breach we have in the law of contract. We have Mora Debitoris, Mora Creditoris, Prospective Malperfomance, and Repudiation. I'm going to discuss with you each and every form of breach of contract we have just listed before. First of all, we are going to look at Mora Debitoris. Mora Debitoris is the late performance by the debtor where the performance is due and enforceable. It is the failure by a debtor to make timeous performance of contractual obligation which is due and enforceable. Maybe if it's money which has to be paid, the debt will be due. The debtor should have paid that money and the debtor has failed to do so. So there are requirements that should be met before a debtor is said to be in mora. The debt must be due and enforceable. It should be enforceable under law. The debtor must have failed to perform timeously. The delay must have been due to the fault of the debtor. Next, we have Mora Creditoris. Mora Creditoris is a form of breach of contract by a creditor. It occurs in the case where a creditor is obliged to lend his or her cooperation to the debtor and fails to do so timeously. The creditor would have an obligation to cooperate with the debtor to ensure that the debtor is able to deliver his performance in time. So if the creditor fails to cooperate with the debtor, we say the debtor has performed Mora Creditoris. The requirements that should be met for a creditor to be said to be in mora are that the debtor must be under an obligation to make the performance to the creditor. The performance needs to be enforceable and due. Cooperation of the creditor must be necessary for the performance of the debtor's obligation, and the debtor must tender performance to the creditor somehow. The debtor must take whatever steps towards performance that are possible without the creditor's cooperation before calling on the creditor to accept the performance. Then the creditor must delay in accepting performance, and the delay must be due to the fault of the creditor. Next, we have positive malperformance. Positive malperformance relates to the content of performance made in a contract. Positive malperformance occurs when a debtor is performed in a way that is contrary to the terms of the contract. Either the debtor is performed but in an incomplete or inadequate manner, or the debtor is performed an act that he or she was not supposed to do according to the terms of the contract. So it may take one of the two forms. It's either positive or negative. In positive malperformance, the debtor has the duty to do something. Positive malperformance occurs when the debtor duly performs, but his performance is incomplete or defective in some respect. As we are saying, for example, a seller delivers the wrong type of goods, or an employee is repeatedly late for work. Then in negative malperformance, a debtor does the act which is not allowed in the contract. For example, a lessee subleases the property or hangs his laundry from the windows, which is not allowed in the contract. Then the other form of breach we have is repudiation. Repudiation occurs when one party demonstrates that he refuses or he has become unable to honor the deal in the contract. That is, a party to a contract commits this form of breach when, by his words or conduct, and without lawful justification, manifests the intention to no longer be bound by the contract. It is a form of anticipatory breach because it predicts another form of breach. The repudiating party indicates in advance of the due date for performance that he will not perform or accept performance, or that his performance will be late, defective, or incomplete. For example, denial of existence of the contract, refusal to perform or to accept performance, refusal to pay, notification of inability to perform, attempt to cancel the contract, or offering incomplete or defective performance as full performance. Those are examples of repudiation as a breach of contract. Now we want to look at remedies or solutions to breach of contract. Where there is breach of a material term, that is a major term in a contract, the injured party has a choice to either abide by the contract and sue for specific performance and claim damages suffered from the breach, or he may treat the contract as cancelled and sue for damages. Then, if the breach is of a non-material term, the injured party may only claim damages. He cannot cancel the contract. This is a minor breach or a partial breach and is less severe than a material breach, and it gives the harmed party the right to sue for damages, but does not usually excuse him from further performance, that he cannot cancel the contract. So the remedies are specific performance, cancellation of the contract, damages for breach of contract, interdict, and quantum meruit. We'll look at the remedies for breach of contract in detail. First of all, we are going to look at specific performance as a remedy for breach of contract. So specific performance is an order of the court requiring a party to a contract to perform their obligation under the contract. The injured party approaches the court and has the right to claim specific performance from the other party if he is ready to carry out his own obligation under that contract. The court then considers the case and chooses whether to grant the decree of specific performance or not. In some circumstances, it is not given. Let us look at the circumstances where decree of specific performance is not usually given. Where specific performance is impossible, for example, where the contract is one of master and servant, factors such as the closeness of the relationship between the individuals and confidentiality is also considered by the court. Then, where damages would adequately compensate the injured party, specific performance is not given by the courts. Then we have the situation where the contract is rendering of services of personal nature, for example, prostitution. The court cannot give a specific performance order for services of a personal nature like prostitution. Then we also have the situation where it is difficult for the court to enforce its order, for example, the disability or insolvency of either of the contracting parties. If someone is insolvent, so then the court cannot give the order for specific performance. And lastly, where the result of the order of specific performance would impose great hardship on the defaulting party, the courts will not grant that order. Next, we have the cancellation of the contract as a remedy to breach of contract. Remember, cancellation is a remedy which is only available where the parties have incorporated a right to cancel in their contract if there is a breach, or where the breach is of a sufficient serious nature, that is, if it's material to justify cancellation. So we are saying they can cancel if they have said it in their contract that if anyone breaches, they are going to cancel, or if the breach is material enough to justify cancellation. That's where cancellation of a contract is given as a remedy to breach of contract. So the injured party has to make his choice to cancel or not. If he chooses to stand by the contract, he loses his right to cancel for that particular breach. Then we also have the common express terms entitling cancellation that are incorporated in our contracts. These are very common express terms. For instance, we have the forfeiture clause. It is found in the contract of lease. It entitles the landlord to cancel the lease and have the tenant ejected if he is in the breach of a certain specific terms, such as the payment of rent on due days. And then we have foreclosure clause that is found in mortgage contracts. It entitles the mortgagee to call up the bond where the mortgager is in default, and usually by failing to pay interest on due date. And lastly, we have lex commissoria. It is found in the contract of purchase and sale, where the seller is entitled to cancel the contract on breach of one or other of the terms of the contract, usually non-payment of an installment that is in the contract where there is credit sales or hire purchase. That is where we find lex commissoria. Cancellation can be in the following ways. It can be cancellation and restitution, or cancellation and damages, or cancellation, restitution, and damages. The next remedy is damages. This is the compensation payable to the victim by the defaulter of the contract to make good for the loss incurred by the breach. The injured party is entitled to claim damages calculated according to his positive interest, that is, amount of money would have had if the breach was not committed and contract was properly and timeously performed. So damages are claimable in two forms. That is actual damages, loss of actual things incurred. That is loss actually incurred. Then we have prospective damages. That is loss of profits which would have otherwise have been made if the breach was not made by the other party. So damages are claimable in these two forms. Then we have interdict. This is when one party is breaching or threatening to breach the contract. Then the other party to the contract then seek an order of court prohibiting the specified act or acts from being carried out. Circumstances in which an interdict will be granted are that where a party to a contract has a good reason to fear a breach of contract by the other party and would like to prevent the threatened breach, the court will grant the interdict. Or for the enforcement of negative provisions in a contract, that one should not do this and that and that and this and those and that. In that case, the interdict is given. And also after a contract has been terminated, to prohibit interference with parties' rights. And let us look at our last remedy, which means as much as he deserves, or how much is it worth. In this case, compensation is given for work done and labor performed only. Where either work has been done or things accepted under a void contract, or when party in a contract abandons a contract, the injured party, instead of claiming damages, may claim payment for what he has been doing or what he has done in the contract. That was all on breach of contract. Now let us look at the common exam questions relating to this topic. First of all, we have what is breach of contract. Then identify and explain the types of breach made in a contract. Analyze the remedies for breach of contract. Analyze the circumstances under which the decree of specific performance will not be granted by the court. Cancellation is one of the remedies to breach of contract. Explain when and how it is usually granted by the courts. Thank you so much for watching. Remember to subscribe and like so that you won't miss more of the videos I will post